Okay, good afternoon, everybody. Welcome to the Doughty Street webinar on challenging housing allocation schemes. My name is Ben Chataway and I'm a member of the Housing and Social Welfare team here at Doughty Street. I'm going to be chairing the webinar today, but we've got two excellent speakers. Firstly, most of you will know Zia Nabi from the team, the scourge of Birmingham City Council and other local authorities who have suspect allocation practices. It's been a particularly busy year, I think, for Zia, with both homelessness cases and a recent Court of Appeal success with Al-Kundi against Birmingham, and also in allocations work. And Zia is going to be talking to you principally about discrimination challenges against allocation schemes, including by reference to his recent success in the case of Noor in Birmingham. And then secondly, many of you will also now know Alice Irving. Alice joined Doughty Street only 2 years ago, but has had an immediate impact and indeed got shortlisted in the finals for Legal Aid Newcomer of the Lallies last time round. And Alice is going to be focusing principally on residence criteria in allocation schemes. We've got a lot to get through. If you've got questions, please do put them in the question and answer function on Zoom. And we will try and deal with them either as we go along in writing or pick them up at the end of the talk. The whole webinar will be recorded, and both the recording and the slides will be available, including on the website afterwards. So without more ado, what I'm going to do now is hand over to Zia.
Right. Well, good afternoon, everybody, and thank you for attending. Could we have the first slide, please? Right. We'll just start off with some very basic principles by way of introduction. So firstly, a local housing authority must comply with Part 6 when it allocates housing accommodation. What that means is that it must have a scheme for determining priorities and the procedure to be followed in the allocation of housing stock. So that's the key point. That's the reason we have allocation schemes, is because there's competition for limited housing stock. And therefore you have to have a scheme to determine who is going to be prioritized over someone else. Now, the local authority doesn't have a free hand in determining priorities, because in determining priorities, the scheme has to be framed so that reasonable preference is given to prescribed categories of applicants, described in one case as being given a head start. So there are some categories of applicants who must be given a reasonable preference under the allocation scheme. Then, as a matter of law, the authority just can't allocate to anyone that it chooses. It may only allocate to both eligible people, and that's to do with their immigration status, and qualifying persons. And those are people who satisfy the requirements of the scheme. And in recent years, we've had people who don't qualify because they haven't lived in the authority's district for long enough, or because they're guilty of what's said to be unacceptable behaviour. Either they've run up rent arrears or they've been guilty of antisocial behaviour. And that's given rise to some case law. But the power to set qualification criteria is subject to the reasonable preference requirement. So you can't set your qualification criteria in a way that effectively negates the mandatory requirement to give reasonable preference to prescribed categories of applicants. May I have the next slide, please? Now, in terms of how you determine priorities and what factors you can take into account, well, you can take into account the financial resources available to a person to meet his housing costs. So the authority could say millionaires, even if you satisfy every other criteria we have on the allocation scheme, you're not going to be allocated accommodation because we've had a look at the financial resources available to you. The behaviour of a person. So if the authority says, well, you were evicted from your last property for antisocial behaviour, so we don't think you're a suitable tenant to have, and you can't have disqualification for life, but you could have temporary disqualification for a period. And then local connection. authorities are allowed to say, well, we're going to prioritize people who are in our district rather than people who've just moved in. And that has led to some interesting cases as well, as we'll see. There's also a code of guidance. We're all familiar, I suspect, with the Homelessness Code of Guidance, but there's also an Allocations Code of Guidance. It is updated from time to time. Paragraph numbers change, so it's worth looking up on the internet to see that you're looking at the latest version. So you've got to have regard to the Code of Guidance, and paragraph 3.26 is important because it sets out clearly that authorities have got to have regard to their duties under the equalities legislation, as well as the reasonable preference requirement. Next slide, please. Now, having said all that, authorities have a wide discretion. And in the case of Armagh and Newham, London Borough Council, there was a culmination of a long line of cases where applicants have been challenging their priority under the scheme by saying, well, you haven't given us a high enough priority because you've looked at this need of mine, but you haven't looked at other needs. You should be carrying out a composite assessment of my needs. And if you did that, then I would get a higher priority than you've given me. And I think the House of Lords just got a bit fed up with that approach because of a number of cases there had been. And they said, well, look, authorities have a wide discretion as to principles on which their scheme should be framed and the way in which housing accommodation should be allocated. And really, I think, perhaps Ben and Alice may disagree with me, but I think that had a chilling effect on allocation policy's challenges. And for a number of years, a very conservative approach was taken by lawyers as to whether an allocations policy could be challenged or not. Well, I think we can remind ourselves that even though the House of Lords appeared to be giving a hands-off direction, they did say that the scheme must comply with the statutory requirements, it must be rational, and it must be lawfully and fairly operated without unlawful discrimination. And as we will see, this is the track down which challenges have proceeded. May I have the next slide, please? Now, one more little point to bear in mind, that not only does the allocation scheme decide on who should be selected or nominated for a particular property, but it also determines where on the waiting list an applicant should be placed. Lots of authorities have banding schemes, so people in band A get a higher priority than people in band D, for example, and an allocation scheme is required to have a fair and non-discriminatory way of making sure that people are on the correct banding scheme. May I have the next slide? How is a policy to be interpreted? Because after all, at the end of the day, what is an allocations policy? It's a policy drawn up by a local authority after consultation, hopefully, and approved by its cabinet. And like anything else, it needs interpretation. How should a housing policy be interpreted, the allocations policy? Well, first of all, you can't ask the jurisdiction of the court. The ultimate interpreter of an allocations policy is the court. The authority can't say, this is what it says, and this is what we meant, and that's the end of the story. But what the court must do is to adopt a practical, common sense and non-legalistic approach and allowing for a degree of flexibility. But where an interpretation on its face is not sustainable, the court will declare that the authority has been operating its policy incorrectly because it's misunderstood its own policy. And that the interpretation point arose, and apologies for the rather eccentric and frankly incorrect spelling of interpretation, of Noor and Birmingham. Now, in that case, there were two claimants. The first claimant was mum, and the second claimant was her adult disabled daughter, and who had cerebral palsy with spastic diplegia. And this family were assessed as requiring an adapted property, which meant that under the scheme, they could only bid for property that was either adapted or was capable of being adapted. What did the policy say? Well, the policy said, first paragraph, but I'm just going to slightly digress here. When you look at an allegations policy, most of them are 60 to 70 pages long. You'll find in most policy challenges, it comes down to 1 or 2 paragraphs. It's our skill as lawyers to work out which the relevant paragraphs are and to focus on those and not to be sidetracked by other irrelevant parts of the policy. So do read your policy, but don't get thrown by how long it is. Most challenges, you will be looking at a very specific paragraph. So in this particular case, we were looking at this paragraph. So first of all, it had a general laudable aim to the properties would be allocated to those applicants who needed that size and type of property. And it had another laudable aim. So we'll give a preference for houses with 2 or more bedrooms to families with dependent children. And the policy defined children as being children under the age of 18, so not adult children. Sheltered housing, extra care accommodation would be allocated to older people, and properties with adaptations will be allocated to persons with a physical or sensory disability. Now you will see, perhaps, there's a bit of an ambiguity in this paragraph because because subparagraph 2 says preference for houses will be allocated to families with dependent children, and then the last sentence says property with adaptations will be allocated to persons with a sensory disability. Well, what about a 2 or more bedroom house? Will that be allocated to families with dependent children under 18, or will they be allocated to persons with a physical or sensory disability? Next paragraph. Next slide, please. Well, this is how Birmingham interpreted it. First of all, they said you can only bid on 4-bedroom properties because of the size of the accommodation required to cater for the second claimant's disability. Then when it was pointed out to them, well, you have no 4-bedroom properties, they said, okay, in the exercise of our discretion, we'll allow you to bid for 3-bedroom property. Now, the first claimant, Mum, made a number of bids, and although she was at bid position number 1, her bids were either skipped or withdrawn by the authority. And in particular, one example, 7th of July 2019, she was at bid position number 1 for a 3-bedroom house, and her bid was withdrawn. And what the council said was this: your client's children are all adults, and therefore she is classed as not having dependent children. She continues to be eligible to bid for accommodation, including bids for flats and maisonettes, i.e., wherever the first claimant was in bid position number 1 for a house, even if that house was adapted or capable of being adapted, she would always lose out to a family with dependent children under 18. And that is the way Birmingham interpreted their scheme. May I have the next slide, please? The court found that authority misinterpreted its own policy. It said the true construction of the scheme was to give families a head start in being considered for a house. That didn't mean that they were bound to get a house. And the scheme being operated unlawfully because the absence of children under 18 was treated as decisive in any allocation decision. The court criticised the fact that nothing in the scheme explained what weight should be allocated to families with children in comparison to other applicants. And that, because that lacked transparency and predictability, that had led, unsurprisingly, said the judge, to an effective automatic decision in favour of any family with children. Further, the authority had allocated adapted housing to families with children who did not need the adaptations, cutting across its own duty to make reasonable adjustments towards disabled people. So it's misunderstood its own scheme and acted unlawfully in its implementation. So there's an example of the local authority getting its misunderstanding its own policy. So thank you. We'll go on to the next slide. Now, frequently in allocation policies challenges, you may find that 2 or 3 months before the final hearing is due to come on, that a property appears. Now, it may just be that that's a matter of good fortune. Certainly that happened in Norham Birmingham City Council. I think the hearing was listed in February, and in November, from memory, a house was allocated to Mrs. Noor. And the authority then said, we now invite you to withdraw your claim for judicial review because your claim is academic. You don't need anything. You were complaining about not being allocated a property. You've now got this property with a garden and it's a house. So withdraw. It was argued that no, the claim wasn't academic and that this wasn't the way that the court should proceed. And the Deputy High Court judge agreed. He noted that the claimants had permission to review the lawfulness of the allocation scheme itself, in particular to determine whether the authority was acting lawfully in preferring applicants with children over applicants with dependent disabled adults. So the claimant didn't cease to have standing simply because there'd been a discretionary offer of accommodation. I mean, that's the other point. The authority said we were going to exercise our discretion to give you this unit of accommodation, this house, but there's nothing wrong with our policy. And in quite a powerful paragraph, the court said the public body cannot avoid legitimate examination of the lawfulness of its decision-making by making an exception for an individual affected by that process, and then argue that the challenge to the process should not proceed because it was rendered academic by the exception it had itself made, which meant that the policy would continue and would never be examined by the court. And the judge also noted that there was a claim for damages for breach of the Equality Act and for declaratory relief. So the court was very unimpressed with the local authority's argument that the claim should not proceed because it had become academic. May I have the next slide, please? Right, I'm going to go on. That's just a little part on interpretation and academic challenges. Going back to reasonable preference, Section 166A3 sets out a number of categories of people who are have to be given a reasonable preference, the Head Start. I've just given 4 examples here, I mean, it carries on. But if you're homeless within the meaning of Part 7, you get a reasonable preference. If you owed one of the housing duties, you're given a reasonable preference, and then in sanitary overcrowded housing, people who need to move on medical or welfare grants. Particularly A is important, I think. People who are homeless but not owed any duty at all, apart from the duty to be provided with advice and assistance, are still required to be given a reasonable preference under the scheme. It may not be very much, but they have to be given that reasonable preference. May I have the next slide, please? And under reasonable preference, going back to the Code of Guidance, the Code of Guidance says, avoid setting criteria which disqualify groups of people whose members are likely to be accorded reasonable preference for social housing, but they can adopt criteria which could disqualify individuals who satisfy reasonable preference requirements. For example, if they're disqualified for antisocial behaviour. So you're giving the group as a whole reasonable preference, but then within that group, you're saying certain people don't qualify because, for example, their own conduct. And also, another example we'll see, because they haven't lived in the authority long enough. And fine, can we have the next slide, please? So I'm going to go these slides very quickly because Alice is going to be discussing this in slightly more detail. But the Court of Appeal restated all eligible persons in the reasonable preference groups must be treated as qualifying for inclusion in the allocation policy, and also noted that being given a reasonable preference is no more than a head start. You can be given a reasonable preference and never be allocated accommodation. The difference between Part 6 and Part 7 is Part 7 is a results duty which requires accommodation to be provided where an accommodation duty is accepted. Part 6, you can be on the register and you may never ever actually be allocated accommodation. Next slide, please. Ben's case of Giacomo Chivute and Hammersmith and Fulham made this point very clearly. So under this scheme, Hammersmith and Fulham said that people who were placed in long-term suitable temporary accommodation under the main housing duty would not normally qualify for inclusion on the Housing Authority's register unless they needed to be on the register for some other reason. For example, the property was about to come to an end or it was not suitable. And the Court of Appeal said that's wrong. You can't do that. Simply because you put someone in suitable temporary accommodation under the main homelessness duty, where someone carries on as being homeless or carries on being owed that duty, Section 166A(3) says that they've got to be given a reasonable preference under the scheme. That's a fundamental requirement. The way that the scheme was drafted, it excluded a whole category of person, rather than, a whole group of people, rather than individuals within a group. And therefore, it effectively was against the law. It was against what the statute required. And the allocations policy was struck down. May I have the next slide, please? Okay, I'm going to move on now to the Equality Act. Now, this isn't, you'll be perhaps relieved or disappointed, depending on your point of view, a seminar on the Equality Act. It's on allocation schemes. We simply don't have time, but just by way of recap, the types of discrimination prohibited by the Equality Act are direct discrimination, discrimination arising from disability, whether it's direct or indirect, indirect discrimination, and discrimination by failing to make reasonable adjustments. That's the type of prohibited activity under the Equality Act. May I have the next slide, please? And an allocations policy, the drafting and the operating of an allocation scheme is the exercise of a public function or provision of service. Noor made that clear. That was another thing that Birmingham challenged in Noor. They said, well, how we run an allocation scheme doesn't fall under public functions, it falls under premises, part 4. And the court said, no, it's part 3. So section 29 says you can't, in the exercise of a public function, do anything that constitutes discrimination. And 29(7)(b) says a duty to make reasonable adjustments applies to a person who exercises a public function. The reason why that's so critical, 29(7)(b) is so critical, is that that imposes a preemptive duty on the authority to make a reasonable adjustment, whereas any reasonable adjustment required in respect of a premises duty is reactive. The authority is only under a duty to make that adjustment once it's requested. So it's much more difficult for the authority to get out of making a reasonable adjustments under part 3 because it doesn't have to wait for it to be requested. So it's a very important point. I have the next slide, please. Now, I'm not going to read this out, but you'll know that reasonable adjustments are all about where a provision, criteria, or practice puts a disabled person at a substantial disadvantage in relation to relevant matter in comparison to people who are not disabled, then steps have to be taken to avoid the disadvantage. Substantial means no more than minor or trivial, so it's not a very high threshold. And disadvantage is not defined in the Act. It just includes a denial of choice. It's enough for a person to say we would have been preferred to be treated differently. That is a disadvantage. Right, may I have the next slide, please? So the failure to comply with the duty to make reasonable adjustments is discrimination, as I said, and a part 3 claim there's an anticipatory duty to make reasonable adjustments. May I have the next slide, please? What is a PCP is not defined in the Equality Act. Or in a Sherlock and Transport for London, it said all 3 words carry the connotation of a state of affairs. It's the way in which things generally are or will be done. Now, the reason I've included this slide is sometimes the allocations policy says one thing on its face, but how it's actually being operated is very different. Well, the way that it's being operated also satisfies a requirement, the definition of a PCP. So the authority can't say, oh, well, you can't challenge our policy because look at this paragraph, it's perfect. There's no issue here at all. And that sort of case, you'd point to what's actually going on the ground and say, no, there's still a problem here. We have the next slide. If you're going to mount an Equality Act challenge, then I would strongly recommend that you have a look at the case of ESOP and the Home Office, which is sort of one of the leading cases as to how PCPs are to be interpreted. It's Baroness Hale judgment. And actually, there are some points which, once you read them, make sense, but you wouldn't necessarily perhaps have thought of them yourselves. And certainly, the Court of Appeal's decision was overturned So the Court of Appeal hadn't thought of them. You don't have to show the reason why a PCP puts one group at a disadvantage. It's enough that it does. The protected characteristic doesn't need to be the reason for the less favourable treatment. All you need is a causal link between the PCP and the disadvantage suffered. The aim is to achieve a level playing field. The aim is to achieve equality of results. The reason for the disadvantage need not be unlawful in itself. So in No, for example, the reason for the disadvantage was because they were trying to help families who had children under 18 to have houses with gardens. That's not an unlawful reason, but it did put families who had disabled adult children at a disadvantage. There's no requirement that every member of a group be put at a disadvantage. It's enough that a sufficient number are. And so it's commonplace for particular disadvantage to be established on the basis of statistical evidence. And the court pointed out, as Lords, it's always open to the respondent to show that the PCP was justified. May I have the next slide? Now, as far as adverse impact is concerned, this is where burden of proof is relevant. So the person who's complaining under the Equality Act has got to show a prima facie case that they are disadvantaged under the way that they, for example, the allocation scheme is being operated. And if they do that, if they demonstrate a prima facie case, then the burden shifts to the defendant to demonstrate there's no discrimination on the balance of probabilities, which involves analysis of evidence. And the court is entitled to draw adverse inferences. Now, the authority can also say there is discrimination, but it's justified. But this is a different point, which is the authority trying to show with evidence that there's actually no discrimination going on. May I have the next slide? An administrative court or county court, most allocations challenges tend to be brought in the administrative court, and I don't know if any that have been brought in the county court. But if your claim is just under section 29, rather than any other section, then the Hamlet and Essex County Council, not an allocations case, I hasten to add, so that claims under section 29 must be brought in the county court because it envisages there be factual disputes, and it said the admin court is not well suited to hear that type of dispute. And so norm permission will not be granted where there's an adequate alternative remedy. Now, although that is, I have to say, that in a number of allocation challenges that I've been involved in, certainly in the last 2 to 3 years, the court has never refused permission on the basis that you should be in the county court, and the court is giving permission. But nonetheless, there is a caution. What can happen under the Equality Act, and what's going to happen in No, is that where you include a claim for damages under the Equality Act, as well as general public law ground of challenge, the court, after having determined the judicial review, can transfer the damages part of the claim to the county court for there to be a trial on the damages claim. May I have the next slide? And then what remedies can the court grant? Well, the court in the county court can grant any damages that could be granted and claimed for judicial review. That means it can technically, where you've got an Equality Act claim, grant mandatory order. One of the few circumstances where a county court has the powers of the administrative court. And then damages, you can get compensation for injured feelings. But if the indirect discrimination is unintentional, the court first of all considers, is there any other disposal before it goes on to damages? May I have the next slide? And what you get for injury to feelings? Well, that's with reference to the Vento bans, updated more or less every year. There are 3 bans. The lowest award and the lowest band is 990. The highest award in the highest band is 49,300. Although very rarely the court can award more than 49,300. I suggest you're not going to get much for a damages claim in most allocations challenges where there has been indirect discrimination. Direct discrimination, another kettle of fish, but indirect discrimination, we're probably talking the lower band in No, but by from recollection, I think damages were agreed at either £4,000 or £5,000. May I have the next slide? So I'm just a couple of examples of allocations cases. So H and Ealing London Borough Council, the Ealing had a scheme where they gave extra priority to people who were in work because they wanted to sort of have a working community. And said, if you're in work, we're going to give you some additional preference. And the court held that the Working Households Priority Allocation Scheme discriminated against disabled persons who were less likely to be able to satisfy the requirements of needing to be in work. The court also noted there hadn't been a proper equality impact assessment to reach public sector equality duty. There's no analysis of the number of non-working disabled people who have been overtaken or at risk of being overtaken by working people lower down the same priority band or on a lower band. But just in passing, my experience generally in the Equality Act challenges is that challenges which are relying on disability as a protected characteristic appear to be met more sympathetically than challenges relying on other protected characteristics. That may just be my experience. It may not be across the board, but I don't think it's coincidental. I mean, we've got Alice will be looking at the case of Gulu and Ward, which dealt with race in very particular ways. But a lot of the challenges that come to me appear to be based on disability challenges. And that's because the Equality Act gives you such concrete rights for disabled people. For example, Section 20 of the Equality Act expressly refers to disabled people. Section 15 of the Equality Act specifically refers to disabled people. May I have the next slide? So I'm not going to go through this slide of Ward and Hillingdon because I think there's a bit of duplication of Alice. So may I have the next slide? And I want to leave her enough time. Could you go just one back, please? Because I do want to talk about this one. So the only point I want to make, this is a general point, is the court said compliance with public sector equality duty involves a duty of inquiry. You can't simply say we've complied because here's our shiny paragraph saying we've complied and we've thought about the Equality Act. There's got to be a duty of inquiry. And although it's impossible for the policymaker to assess the potential indirect discriminatory effect on every conceivable group, so they may be able to satisfy the court at that stage. But once someone raises something and it hasn't been adequately looked at, then by not looking at it, by not making inquiry at that stage, there is a breach of the PSCD. So you're not just looking at what the state of play was at the time that the allocations policy was brought into force. If something hasn't been looked at, you say, look, we need to look at this, and the authority refuses, it's not too late to raise a breach of PSCD ground. May I have the next slide? So Noor and Birmingham, just to remind you, you've seen this already. I'm just looking at the Equality Act aspect of the case now. Just remind yourselves of what the policy said. So the houses with 2 or more bedrooms would be given to families with dependent children. Next slide, please. Now, Mrs. Noor was allocated, assessed as needing an adapted property. And that meant she could only bid for adapted accommodation or accommodation that was capable of being adapted. But there was no adapted accommodation or accommodation capable of being adapted that wasn't a house. I mean, it makes sense as to why houses are easy to adapt, easier to adapt, and flats are quite difficult to adapt. And the policy was operated by the council that the absence of children in a family was treated as decisive. So the family with children under 18 would always trump a family with a disabled child over 18. May I have the next slide? And we managed to find an ONS, the Office of National Statistics report, which said disabled people were much more likely to live in social housing than non-disabled people. So you're already looking at more disabled people when you're talking about social housing. Disabled people aged 24 and over were significantly more likely to live with their parents than non-disabled people in the same age group. So if you're a disabled person who's over 24, you're significantly more likely to live with your parent. And disabled people with autism and those with severe learning disabilities were by far the most likely to live with their parents into adulthood. But both these categories of people would always be trumped by a family with children under the age of 18 when they were bidding for a property. May I have the next slide? So the court found, firstly, that the council had misunderstood its own policy, and we've already had a look at that. And then the court said it's no defense or discrimination claim for the unintentional discriminator to say they were unaware of the discriminatory effect of the decision-making system. And the comparison in this case was between persons on the register applying for properties and had a disabled person in their household and persons who did not have a disabled person on their household. Non-disabled households were able to bid for all properties on the council's list because they could bid for houses that were either adapted or capable of being adapted as long as they had children under 18. May I have the next slide? But disabled households could only bid in practice for adapted properties. A had a diminished pool of properties they could bid for, and that pool was further diminished because houses were prioritised for households with children. That was said to be a particular disadvantage. The judge also, this wasn't a strong part of the judgment, but he noted, he accepted the submission, that disabled households were less likely to be able to bid successfully houses than non-disabled households because they were less likely to have a child under 18 in their household. They were more likely to be living with their parents as adult children. They were less likely to have their own children. May I have the next slide? Now, the council said, the judge said the decision to offer a measure of preference to houses for families with children was a legitimate aim. So the court understood why the council wanted to do it. And in a way, it was a laudable aim if you're looking at it through the prism of what children need. But the council had failed to justify this policy. The court said we're obliged to look at how the policy worked out in practice, not limited to looking at the words of the policy itself. The reasons advanced to justify giving a preference for houses to households with dependent children applied equally to households where a member was a young adult with learning difficulties, i.e. they needed houses with gardens just as much as houses as families with children under 18. And there was no evidence to show that the remaining pool of properties still left disabled households without children under 18 with a reasonable pool of properties they could bid for. The council didn't provide that type of evidence. And the court, this is the key point in my view, often the council in a policy challenge will point to a residual discretion and say it gets home, because even if anything is potentially unlawful on its face, it can always be remedied by the exercise of discretion. And the court said it was not an answer to say that the council retained a discretion to allocate property outside of the bidding system, as in fact they had done in this case to Mrs. Noor. Next slide, please. The court said allocation policies fall within part 3. There's a proactive duty to make reasonable adjustments. The question was, did the policy put disabled people at a substantial disadvantage, more than minor or trivial? It did, and the council had taken no steps to adjust the policy. May I have the next? And they could have done that, for example, by having more stock available or by making sure that people weren't immediately ruled out for houses simply because they didn't have children under 18. And those are sort of the examples that the court gave of reasonable adjustments that could have been made. May I have the next slide, please? The PSED. Now, although the PSED challenge wasn't allowed, although we spent a long time arguing about it, it was an everyone's skeleton argument, the court said, well, it hasn't been properly formulated as a ground. And frankly, I think by the time the court had decided the policy was unlawful, it didn't need to consider the PSED. But the court, an argument that was made and the court accepted was that once a policy is brought into place by an authority, there's got to be ongoing monitoring so that the authority can ensure that their due regard is being paid to the PSED with respect to protected characteristics. And the court, Birmingham City Council hadn't been doing any monitoring of how its policy was working out in practice. They accepted that made it very difficult for them to demonstrate the discharge of their public sector equality duty, because they simply didn't have any reliable information. So whenever you have an allocations policy challenge and a PSED challenge, please always do ask for information about how the existing policy is being monitored to make sure that the PSED is being complied with. Because if there's no monitoring going on, that on its face is a clear breach of the PSED. May I have the next slide? Birmingham carried out an equality impact assessment, and the court said, well, we can't criticize Birmingham for not having foreseen every single problem, as similar to the HA decision. But, said the judge, the council had never reviewed how the policy was working in practice. There'd been no analysis, and it had been operating a scheme for 4 years without knowing whether it achieved the objectives which it was intended to achieve, or whether it impacted adversely on groups of residents with protected characteristics. May I have the next slide, please? Now, this is the last slide. Damages were relatively modest for the reasons that the court said it couldn't be clear that even if the policy had not been unlawfully discriminatory, that Mrs. Noor would have been allocated something much earlier than she had been, although the court said it probably would have been before the hearing, but couldn't say when. It asked parties to agree damages, and as I say from recollection, damages agreed with either £4,000 or £5,000. Well, thank you very much for that. Apologies if I've gone over slightly. I'm now going to pass on to Alice.
Thank you very much, Zia. Can I just check on my screen? I'm able to see the question and answer box open. Is that showing for you, or is my screen clear in terms of the slide?
I can see the question and answer box open, but I can also close it.
I'm just wondering if my screen share is causing you to see my question and answer box.
I don't think it is.
Okay, good. Well, I'll crack on. I just wanted to check. So following on from that very thorough overview from Zia, I'm just going to focus on a couple of example cases that concern challenges to residency requirements in allocation policies. So we've already covered the basic framework, but just a reminder, because I know we've covered a lot of content today, that Section 160ZA is a new introduction under the Localism Act, which enables a local authority in their allocation scheme to specify who is and who isn't a qualifying person. And that effectively means that a local authority can say this kind of person doesn't qualify to be on the list for housing allocation at all. And then a reminder about what those reasonable preference requirements are, that there are a statutory obligation on the local authority to ensure that their scheme, however it's drawn, does provide reasonable preference to certain individuals. And also that scheme may contain provision to give priority to individuals taking into account a range of factors, including local connection, and the definition of local connection is carried over there from Section 199 of the legislation. So we've also referred briefly to the statutory guidance, which local housing authorities have a duty to have regard to, and I believe that Zia has already drawn out these relevant provisions, so I'm not going to, in the interest of time, read those any further, but that concerns the relationship between criteria for a person to qualify for joining a housing register on the one hand, and that the other kind of matters that must be taken into account, so discrimination, legislation, and the reasonable preference requirements. So where does that leave us when we've got an allocation policy, it has residency requirements, and perhaps we have a client who doesn't meet that requirement and we're considering whether we can challenge the policy itself? The starting point is that it's very clear from the legislative framework and the statutory guidance that residency requirements are within the range of things a local authority can do, and in fact quite strongly encouraged by the Secretary of State in that statutory guidance. Nevertheless, as we've already noted, it has to be the case that a scheme is lawfully and fairly operated, and it can't be indirectly or otherwise discriminatory in its content and application. So I want to consider briefly two cases where there have been challenges to residency requirements, and the first being the Montero case and the second being the Gulu case. The first was unsuccessful, unfortunately, and the second was successful. And they involved challenges on two different types of grounds. The first is a sort of a straightforward unlawfulness challenge in a sense, and saying that the scheme in putting in place a residency requirement didn't adhere to the requirements to give reasonable preference to certain individuals, as set out in section 166A3, and the Gulu case is a discrimination challenge. So Montero, this was a case where there was a local connection requirement of 5 years in effect. There was a bit of nuance around how that was applied, but effectively you were looking at 5 years in order to be able to get on that housing allocation list. It was argued that this was unlawful because effectively this prevented someone like the claimant in this case, who was living in overcrowded accommodation, from being given reasonable preference under the allocation scheme. And you will recall that under the legislative regime, a person who's in overcrowded accommodation has to be given reasonable preference in the scheme drawn up by a local authority. And so the core of the arguments was that it was unlawful to impose a requirement that excluded a subgroup of persons from allocation. Unfortunately, the case wasn't successful, and the court drew a lot of distinctions here between this case and the case that was discussed earlier by Zia. So in that earlier case, you'll recall that there was a allocation scheme that said that a homeless person who was in long-term and suitable accommodation under the homelessness regime was excluded or disqualified from being placed on the register for housing. And the court there said that that was contrary to the statutory requirement to provide reasonable preference to individuals with who were homeless. The court said that that was clearly distinguishable from the present case in Montero, and there were a couple of reasons for that. The first was that in the case involving homeless individuals, there was a clear carving out or cutting down of that category of person who ought to be given reasonable preference. The legislation said the individual who was homeless should be given preference, and the scheme had come in and really sliced that down to say only these particular types of homeless people should be given preference. And that was seen to be a direct contradiction really to the legislation. In addition, there was statistical evidence that showed that in fact around 87% of individuals who were homeless were in this long-term suitable accommodation, which meant that basically the vast majority of the cohort who ought to have been given reasonable preference under the regime were not being given reasonable preference because of this criterion that had been placed in the scheme to access the housing list. Now, there was a real contrast between that and the case in Montero, where first of all, there was a residency requirement. So there wasn't any carving down of, say, here overcrowding was the relevant basis on which reasonable preference was claimed. And they said, well, we've not said that only certain types of overcrowded people will qualify. Residence is an individual and separate consideration, and it is legitimate in principle to impose that, and for that to sometimes lead to the exclusion of individuals who might otherwise have had reasonable preference. And then the second point was that actually looking at the evidence that was before the court in Montero, it wasn't actually abundantly clear that a high proportion of individuals were, as a result of this application of the scheme, being excluded from reasonable preference. And so depending on which of the parties' evidence you referred to, if you took the evidence at its highest, we're talking about a third of people who are overcrowded, potentially who had applied to go on the housing register had not been able to do so because of the residency criteria. So again, that was distinguished because you still had a large cohort who were being given reasonable preference. And so a key distinction coming out of the case is this distinction between a direct attempt to thwart, as the language, the statutory giving of reason to certain groups, and the application of general rules such as residency requirements, which really are sort of a separate rule that doesn't directly undermine the reasonable requirements categories identified in the legislation. And again, there's the distinction between this case and the Giacomo-Kitty. You can see I've been trying to avoid saying that, bless, forgive me, where the evidence also is much stronger that there was a large cohort of people who were not being given reasonable preference who ought to have been. And again, here is the sort of key findings that we ended up with in the Monterey case. So I think some of the sort of interesting things to think about in relation to this is, with a residency requirement, are we ever going to be able to say that allocation scheme is unlawful because it cuts across the reasonable preference requirements in the legislative framework? There is a prospect potentially, although I think you'd have to have fairly good evidence, and I know that Ben and Zia might have thoughts on this. In the judgment, there was some reference to some of the kind of portions of the statutory guidance which were drawn out earlier by Zia, where the statutory guidance should be avoided that result in disqualification of people who are in a reasonable preference category. And what the judge says they understand that to mean is effectively that you should look out for the application of criteria, for example, residency criteria, that disproportionately adversely affects individuals who should be given reasonable preference. Now, we know from the Monterey case itself that a court's not going to be particularly impressed by, say, a third of a cohort who should be given reasonable preference being barred from joining a housing register. We know from the earlier case, whose name I'm having difficulty pronouncing this evening, that if you're about 87–90%, court might raise an eyebrow and wade in. I guess there's a question as to at what point the effect, if you can evidence of it, of a residency criteria or indeed other criteria in an allocation scheme will be such that the impact on a group that should have reasonable preference is sufficiently disproportionate to be said to be contrary to the legislative regime and to be unlawful. And so I think there's a live question there to be clarified in later cases. Great. And then the second case, very briefly, because I'm mindful of time, that I was looking to consider was the Gulu case. This is in fact two linked cases that went to the Court of Appeal, the Ward case and the Gulu case. And they involved a challenge, both of them, to the Hillingdon local housing authorities allocation scheme, which required there to be a period of residence in order to qualify. Although notably, there was actually an additional carve out added into that residence qualification requirement, so that sort of perhaps in response to some of the concerns being raised in cases concerning reasonable preference, they said, okay, well, you have to have lived here for 10 years, or if you've got reasonable preference, you can get on the list. But then even if you got on the list, if you hadn't been living in the area for 10 years, you are going to fall in basically band D. So that's the residence uplift there as described, which is effectively someone who had been resident for such a long period of time would be given preference over others. So in fact, in this case, both of the claimants in the separate cases were allowed onto the list because they were people who had reasonable preference. However, they were in band D because they didn't attract the residence uplift because of the period of time that they had been in the area. And the two different claims concern two different individuals or groups. There was more than one claimant in the case involving Irish travellers. So the first involved individuals of Irish traveller descent who had lived a lifestyle that wasn't settled, and it was part of obviously the traveller lifestyle to be somewhat nomadic, had decided at this point that they wanted to settle, and then faced the barrier of not being continuously resident to be able to get a decent banding in terms of allocations. The Gulu case concerned a refugee who had initially been accommodated by the Home Office or under the asylum regime. And when he'd been given leave to remain, he'd applied as homeless and again faced a barrier from Hillingdon in relation to being given adequate or useful banding, really, because of the residency requirement. And in his case, part of the issue was that while he was in accommodation that was being provided during the processing of his refugee application. He was possibly going to be moved around quite a lot from place to place in a way that was outside of his control. And obviously he hadn't been in the UK for particularly long. So in the case, it was kind of an odd one in terms of the history. So in the Ward case, which was the case involving Irish travellers, at first instance, the case for indirect discrimination was successful on the basis that the residency requirement and also the residency uplift disproportionately or disadvantaged individuals from an Irish traveller background, and that they had a protected characteristic of race. On the other hand, in the Gulu case, in fact, Hillingdon had sought to concede the same logic applied, so effectively that the residency requirements disadvantaged individuals who were non-EU nationals or non-UK nationals, and that disadvantage was linked to the protected characteristic of race. But the judge at first instance there had not accepted that concession. And it's useful, in fact, to consider if you're ever sort of thinking about that difficult question of which is my correct comparator group, which can sometimes be a bit of a sticky issue, to look at the Gulu case and see the criticism of the Court of Appeal of the earlier decision-making process carried out at first instance to show how those comparator categories can be misconstrued. So by the time we get to the Court of Appeal, everybody's on the same page that effectively the only issue in play is justification. And really what's interesting about this case, I think, and which builds importantly on the point made in Nur, is that a discretion or other safety valves in a system is not going to be good enough to just point to and rely on if you get sort of to the point of needing to justify indirect discrimination. And I'll elaborate on that a bit as I go through. But before I talk a little bit more about justification, just one little point to look at. So there is a bit of a question mark in this area about the standard of scrutiny that a court should adopt in the context of an Equality Act challenge, where you're dealing with housing allocation, which is obviously a highly sensitive policy area involving allocation of limited resources. So Gulu itself internally, just drawn out a couple of paragraph references there, is a little bit unclear about whether the sort of standard of manifestly without reasonable foundation, which is the standard applied to Article 14 challenges, should also apply in the Equality Act context. I would say Gulu's potentially, if you're reading it uncharitably, internally inconsistent on the point. I've just included a little reference there to one of the leading textbooks in the area, where they say that probably following the ZK case in the Supreme Court, that manifestly without reasonable foundation is not to be applied in the Equality Act context, which is good news, obviously, for claimant lawyers in this area. But it's a potential argument to be alive to, because it's not entirely been laid to rest. This is the point that was already covered by Zia in relation to the public sector equality duty, that you don't need to kind of guess or cover every potential group that might be discriminated against, but once an issue has been raised and it's been pointed out to you that, for example, your allocation policy impacts on refugees or Irish travellers in a discriminatory fashion, at that point you should be looking into it. And interestingly as well, the case also refers in passing to the Section 11 duty under the Children's Act 2004 to discharge functions having regard to the need to safeguard and promote the welfare of children, and similarly says that if an issue is then flagged to you that engages that duty, it's not enough to say, well, we couldn't have foreseen it earlier, you need to look into that. So as sort of a parallel analysis is carried out for that Children's Act duty, so it's always worth thinking, if there are sort of children in the mix, are we just in the PSCD or are we also under the Children's Act? A few other things about justification in this context. Ex post facto reasoning can be relied upon, but usefully it's underlined in the Gulu decision that should be subject to greater scrutiny by a court. And then this really important point about safety valves in the overall scheme. So this links into some of the observations in Nur about when local authorities say, well, we had a discretion that we can exercise, and that can deal with the fact that there's disadvantage to this particular group of people with a protected characteristic. Here, the local authority, Hillingdon, tried to do that again. They said, look at the overall scheme. And when they said overall scheme, they didn't just mean the allocation scheme. They also meant Part 7 and the homelessness regime. And the court said, well, it's not good enough. None of these safety valves have been shown to, in fact, counteract the disadvantage that is present to this particular cohort of people, either Irish travellers or refugees. So if you've got a local authority who's seeking to rely on that kind of argument, they're going to need to evidence it really well, a sort of vague gesture towards the fact that there are other routes potentially to allocation of housing is never going to cut the mustard. And so again, that's really useful and can be linked to the point that's been drawn out by Zia in the Noor judgment. In terms of in the case, again, I think that there's a lot to be said about the kind of evidence the court might be expecting to see from a local authority seeking to justify a policy that's prima facie discriminatory. So here there wasn't any evidence of the impact on disadvantaged groups or what the effect would be, say, if they relaxed or had a carve out for the residency requirement. So if they were saying, well, it'll undermine our objective of ensuring that, you know, people connected to the community are rewarded and prioritised. Well, there was no analysis or evidence to show what would happen if you had a carve out to your ability to meet that objective. There was also criticism of any tendency for the court to try to construct arguments that simply hadn't been put forward by Hillingdon. So again, really strong onus on a local authority to evidence things themselves. And I think this is an interesting point, again, to link to something that Zia pulled out in the Noor case. So there he said that under the public sector equality duty, a clear breach would be if you put in place a duty and then you've not continued to monitor it. In Gurlu, one of the things Hillingdon tried to say is, well, we've been monitoring the policy, so, you know, that means we're the good guys. And the court said, well, it's not enough that you're keeping a policy under review to show that you can justify indirect discrimination. If in fact the policy remains indirectly discriminatory, that's not going to get you out of jail free. And then finally, there was some suggestion from the court about precisely how the indirect discrimination might be addressed in a way that would be lawful, because one of the things Hillingdon had tried to say is there's no way for us to address this without discriminating against somebody else, and the court didn't have any time for that. So that was an absolutely really, really quick chop through those two cases, because I'm aware that it is Monday, often for lots of us, of the first day back from work, and it's 5:05. So I'll hand back to Ben and see if we've got any questions.
Thanks, Alice. We have one question posted in the Q&A bit. How can the policy be monitored? And maybe I'm going to hand over to Zia to address that.
All right, thank you very much. So the starting point is you're asking a local authority how they're monitoring a policy. So I would just simply write a letter to the authority saying, this is what your policy says under the public sector equality duty. You've had due regard to it in making your, in adopting your policy, and they may or may not have identified any potentially discriminatory aspects to it. Or remember, the public sector equality duty is not just about avoiding discrimination, but it's actually about promoting equality of opportunity, advancing equality of opportunity. And so you could simply say, what monitoring are you carrying out to ensure that you're complying with the public sector equality duty? If they're not carrying out any monitoring at all, and your case is, my client has a protected characteristic and they're discriminated against by the way that the policy operates in the following ways, the failure to carry out any monitoring of that means that they're in a difficult position to say, no, you're wrong. And so I think you would, at the initial point, I would simply want to get into that exchange of correspondence with the authority to see what they have to say. And how you monitor is a different, it's not something I've had to address, but how you monitor would be by looking at saying who's who you've got on the register, what protected characteristics they have, if any patterns are emerging about who's being allocated accommodation and who is not, if there are any patterns emerging about how points are being given, how banding is working. I.e., what they've got to do is carry out an on-the-ground analysis of how the scheme is operating in practice, and whether in its operation it's either disadvantaging people with protected characteristics, or it's failing to make sure that due regard is being had to those protected characteristics. So remember, the PSCD is a due regard duty. If you're not carrying out any monitoring at all, how are you having due regard?
Alice, I think you wanted to add something.
Oh, no, I didn't. Sorry,
You
I
didn't.
was clearing the questions in the
No
Q&A
problem.
box, pressing buttons. No, I fully agree with Zia that I don't think it's for us to tell local authorities how to monitor, but if they're not monitoring at all, then...
And it's going to be very fact specific, isn't it? I think it will depend on how you think the policy impacts adversely on any protected group. So you're just going to have to think on the spot, I think, about what sort of data might be gathered. And one last question, because we're a bit past the time already, but Rachel Lovell has posted a query. If monitoring reveals there's a discriminatory impact, is it sufficient in the interim that the authority are going through a process to address it, e.g. to consult on changing their policy, especially when that process could go on for months or years? Or is there a claim on the basis of those affected now? And I guess this will depend on part on what your challenge is. If you think there is actual discrimination, then, I mean, you could claim now, and the court will decide for itself whether there is disproportionate impact or whether it's justified. If your claim is purely for breach of Section 149, then the position is likely to become much more nuanced, I think, with the court, as it did in the Ward case, weighing up what's being done to comply with Section 149. And even if there's been a breach to date, it may not grant relief if the authority can say it's getting a move on and actually looking at things. So I think it'll depend on what your claim is largely. Has anyone else got anything to add to that?
I mean, the only thing I would add is delay. If the authority is guilty of unlawful delay in carrying out a new assessment, if it says we're going to do one in 5 years' time, we accept we're in breach now, we'll do one in 5 years' time, then that there the challenge would be you're guilty of irrational delay, because the breach to PSCD would be given. In that example, it's not in dispute that the PSCD is being breached, and then you would say, well, it's unlawful and irrational to wait 5 years before correcting it.
Yeah. But if there is current discrimination, I don't see how the fact that the authority is looking at it is any defence to a claim based on Section 19 of the Equality Act.
Yeah, I mean, the thing to bear in mind is that the breach of the PSCD doesn't sound in damages, but it can be used to analyse and criticise an existing state of affairs. And if the authority accepts that, for example, that the state of affairs amounts to unlawful discrimination, that gives you a claim now and a claim in damages now. So there'd be no point in waiting.
I'd agree strongly with that. I think I see a lot of this kind of tactic in a parallel area I practice in, which is education law, where you say, you know, this framework, this kind of plan in place for a young person is inadequate. And they said, oh, we're going to review it. So you can't kind of push us right now on delivering what's in the current plan. But if you've got, you know, a current statutory right, for example, or right to education, or here a right to, you know, to show that you've been discriminated against, the fact that they might remedy in that in the future isn't really any answer. I think local authorities like to put it in to try to say, well, you're going to be too early. I wouldn't be put off by that when you're confident that you've got sort of an act for sort of a claim for discrimination now.
Great. Okay, we're already at 5:10, and I'm conscious that it's Monday. So I think we're going to draw a line to it there, but thank you to our speakers, and thank you to everybody who's taken the time to attend the webinar. Have a good week. Bye.
Bye, everyone.